Hello, Rob Ryder again. I'm going to try to use this particular chapter out of Blackstone's Book 22, Chapter 21, of alienation by matter of record, um, to look at land patents and the paperwork that comes afterwards, be it a certificate or a deed, and how it applies to real estate and also real property and interest. We're not going to read this whole chapter, just first number of pages, and then in between mix in some of the instruments that we have and what they might actually be. Okay, so assurances by matter of record are such as do not entirely depend on the act or consent of the parties themselves, but the sanction of the court of record is called in to substantiate, preserve, and be perpetual testimony of the transfer of property from one man to another or its establishment when already transferred. Of this nature there are private acts of parliament, the king's grants, fines, and common recoveries. So, as you can see, the court of record is very much a part of this. And a court of record, such as like at the county level, they can have many special courts. You can have the one that you would go into when you walk in, that's a court of record. Or there's also courts of record such as that are part of this court of record. They're called special courts. Child support is under a court of record, but it's a special court. It only handles child support. Well, there are land courts also that are special courts, and they also are handled by courts of record. And the Register of Deeds office falls under the court of record. So they're tied in together. So let's see what that means to us. Private acts of parliament are, especially of the later years, become very common mode of insurance. For it may sometimes happen that by ingenuity of some and the blunders of other practitioners, an estate is most grievously entangled by a multitude of contingent remainders, resulting trust, springing uses, executory devices, and the like artificial contrivances. A confusion unknown to the simple conveyances of common law, so that it is out of the power of either the courts of law or court of equity to relieve the owner. So what he's saying is in common law, which is what deeds are, it's very, very simple. There is anything to it. The part in red, they're talking about under the fiction, where we use trust and other devices that have tangled things so badly that they're almost impossible for any court to handle. So they have to enact a private act of parliament that by this act, if you agree to the act, then it will untangle this. So one such act would be the Act of Ascension, the Ascension Act of 1910, UK and Commonwealth, which is about a 3 or 4 sentence statement that's done as an acknowledgement by the sovereign. It's the same one the Queen takes, and then she gets her coronation from the Archbishop of Canterbury. But when you read it, it doesn't say anything about England. It just says the sovereign of their realm. And so I think that as a man, you could take that and skip through all this crap and just go take the Act of Ascension. It says on there that you're a faithful Protestant, but when you look up the definition of Protestant, it merely means that you believe that the Bible is the source of the law. I don't see anything wrong with that. And again, you're not taking it as an oath. It's just an acknowledgement. Your free will, act, and deed. All acts are done by your will. Or it may sometimes happen that by strictness or omissions of family settlements, the tenant of an estate is abridged of some reasonable power, as letting leases, making a joiner for a wife, or the like, which power cannot be given to him by the ordinary judge, either in common law or equity. Or it may be necessary in settling an estate to secure it against claims of infants and other persons under legal disabilities, who are not bound by any judgments or decrees of the ordinary courts of justice. And that word ordinary is not there because they're just ordinary like any other one. An ordinary, the archbishop is the ordinary, the province that you inhabit. He has ordinary powers. I think the cardinals and the pope have extraordinary powers. I know that somebody does. I've seen that used. I can't remember if it was just the pope or the pope and the cardinals. So he's over the law. All the courts and civil courts are his. And but it's out of his power even to undo the crap that needs to be done because of common law. This what we just read has more to do with what they're doing with your property now, so that they can, with the estate and so forth, how they can stand in as the proxy owner, which is what they're doing with your real estate right now. Because as the grantee, you've never accepted the deed, right? According to the dictionary in Bouviers, under to record, which is right after record. It's not in the T's, it's in record. Just go to record, it's the next one down. And hang on here. So it says in there that if you haven't accepted the deed as the grantee, that a creditor, that's the word I'm looking for, there it is, there's a creditor that's attached to the land somehow, and he gets the preference. And it's merely because you haven't accepted the deed. And as we know now, people have, and they're getting their deeds to say that that they're the sole owner. Now, an interesting thing about deeds, those deeds, is they're indenture deeds. And so go look up indenture, and then look under law when you get into indenture, and you'll see that these are, an indenture would be the same wording on different pieces of paper, or the same contract, or so forth. And they're an indenture because of the way that the seal is put on there. If you look at the seals, they all have a cut edge on it, and that's a symbol of an indentured deed. And in an indentured device used in law is a three-part device, and the court of record holds one of the pieces. And there's these other two pieces that exist. So, so I believe what's happening when they're changing your you from just the grantee to say sole owner, that piece of paper already exists and the court's holding it, and they're just waiting for you to acknowledge the deed that says you're the grantee, and they slide in the one that says that you own it. That's the way they've been there, ever since you created it. It's an indenture deed. Now, whether they actually do that or it's a statutory equivalent to that's kind of what they're doing. It's an indentured three-part deed. There's three pieces of the same deed with the same information on each of them. But why does the one that's in there now say that you're the sole owner is yet to be found out. Anyways, we'll continue on. In these and other cases of the kind, the transcendent power of Parliament is called in to cut the Gordian knot, and by a particular law enacted for this very purpose to unfetter an estate, to give its tenant reasonable powers, to assure it to a purchaser against the remote and latent claims of infants or disabled persons, by setting a proper equivalent and portion to the interest so barred. So this here is talking about title insurance. That's what this is. This is the title insurance. That because they really can't undo the common law side of the estate, and they know they're going to be working with a marketable title. You have good titles, so they're going to create a marketable title and put insurance on it for the remote and latent claims of infants or disabled persons. As an infant, you can't own land. Neither can a disabled. Only man can own land, and he has to be a man. You have to be the age majority, and know that you are a man. This practice is carried to great length in the years succeeding the Restoration. All this stuff has been going on. It's a plan that goes time after time over generations, so that one generation doesn't know what happened 2 generations ago. They get to write the books we read. But the law is always there. They never hide the law. It's written right here in this book, 300 years old. So the practice was carried out to great length in the years succeeding the Restoration by setting aside many conveyances alleged to have been made by constraint, or in order to screen the estates from being forfeited during the usurpation. So because Martin Luther went and he put his deed on the door of the church. Now in days of old, that is where the people would put their record. They would hang a copy of their record for maybe 3 weeks on the bulletin board or some board at the church. That's where the record was first put. You know, after it was up there 3 weeks, everybody knew. So you would stop by and read the bulletin board to find out what was going on. That's where that comes from. Or the town crier, or whatever it is. But somehow it was made a public record. In the days of Martin Luther, one of the ways was you'd take it to the church. Well, you know, instead of putting the bulletin board, he put it in the door. So take a copy of your deed and go put it on in the church someplace. Put it on our bulletin board. I wonder how long it'll stay there. I don't think they'll take it down myself. And at last it proceeded so far that as the noble historian expresses it, every man had raised an equity in his own imagination. He raised it in his imagination. It doesn't exist. That he thought ought to prevail against any dissent, testament, or act of law. So they think that they have a system in his own mind that will prevail against all of these. However, the king said that the good old rules of law are the best security, and to wish that men might not have so much cause to fear that the settlements which they make of their estates shall be too easily unsettled when they are dead by the power of Parliament. In other words, common law will always prevail. It doesn't matter what they do. They can only do it in their head, which means they have to get your consent. And if they can't do that, and you stick to common law and do the common law way, there's nothing they can do about it. So anyways, to give them the opportunity to do what they were doing, these acts of this kind are, however, at present carried on in both houses with great deliberation and caution. Particularly in those houses of lords, they are usually referred to two judges, to examine and report the facts alleged and to settle all technical forms. So there's 2 judges involved that have to look at this stuff, it sounds to me. One, I believe, is going to be the land court judge for the land, and I believe the other one is the ordinary, the archbishop. That, you know, we're going to be notifying those 2 judges. However, if somebody in the UK can find out who they're talking about here, we would be able to pinpoint who they are around the world. Particularly in the House of Lords, they are referred to 2 judges to examine and report the facts alleged and to settle all technical forms. So who looks at the acts in Parliament? That would be good to know. Nothing also is done without the consent expressly given of all parties and being incapable of consent. They have the remotest interest in the matter, unless such consent shall appear to be perversely and without reason withheld. So their presumption is, this act has been passed, you know, you need to say yea or nay. If you do neither, then they're going to say that you agree. They're going to say it was a yea. Or that it was a nay. They're going to say you can have your land if you do this, and you say yea, okay, everyone will know that I have my land. Or if we don't hear from you, then it means you don't want your land. That's what they're doing now. That, you know, we haven't come forward, and they presume that means we don't want, you know, that we don't want our property. And as was before hinted, An equivalent in money or other estate is usually settled upon infants, or persons not in existence or not in capacity to act for themselves, who are to be concluded by this act. And a general savings is constantly added at the close of the bill of the rate and interest of all persons whatsoever, except those who consent to be given or purchased, and who are therein particularly named. Those who consent so, given, or purchased. So on a call yesterday, a guy was reading his insurance policy on his real estate, and it looks like it doesn't cover the mortgage. So, not that that bothers us. We're going to find out that this is what that insurance is really for us, and what that insurance is, well, that's yet to be seen. But the tax that they're putting on the property, because you've never stepped forward as the owner, and no land should be vacant and not producing what it can, they put a tax on it. And that's what the tax man is. He's been collecting rent for the property. Well, he's collecting it for the proper owner. That's his job. He's just standing in as the owner, waiting for the owner to show up. He has power of appointment, power of attorney. And until we claim it back, that's what he has. But, that's your money. He's holding it for you. We got to convince him of that, but I believe that that's what, what you can read into this stuff when you read it a few times. A law thus made, though it binds all parties to the bill, is yet looked upon rather as a private conveyance than as a solemn act of the legislature. It is not, therefore, allowed to be public, but a mere private statute. It is not printed or published among the other laws of the session, and no judge or jury is bound to take notice of it, unless the same is specially set forth and pleaded. It remains, however, enrolled among the public records of the nation, to be forever preserved as perpetual testimony of the conveyances or assurances so made or established. Now, an excellent example of this is when they passed the Torrens Act in Virginia. It's in the act, but it's not in the code, and it's in the session law, but it's not in the code, because the code is for everybody. So it's not in there, but it references in where it should be, that you can go here to find it. And in this particular book, it was in the appendix you could go to. So they took a one-sentence thing and threw it in place of 40 pages of information that said how the Torrens system worked, and what it was being used for. So that's what these are. They're not therefore allowed to be public. So it's not in the code. It's a private statute, and you're supposed to know about it. The king's grants are also matter of public record. So as Saint Germain says, the king's excellency is so high in law. That's why you want to be the king, people. You don't want to be anything but the sovereign, the king, because you are so high in law that no freehold may be given to the king, nor derived from the king, but by matter of record. So you can't give anything away or get anything except unless there's a record of it. And to this end, a variety of offices are erected, communicating in a regular subordination one within another, through which all the king's grants must pass and be transcribed and enrolled, that the same may be narrowly inspected by his officers, who will inform him if anything contained therein is improper or unlawful to be granted. So if you're the king, everything that you put your seal to, which is your signature in this case, it gets transcribed and enrolled. That's why it goes into the double entry bookkeeping books. And from there, whatever the true value of it is ends up in an escrow account. And we've not had access to the escrow accounts. Well, I think that that's what we're doing with the real estate, is we're taking the escrow account um, that that piece of paper represents, right? Because we're just trading paper. Look, you can't own the land. It's allodial. Allodial title goes to the creator. It's his land. We're not taking it with us. But we can have the certificate of title that they're calling a warranty deed, or a like name, for that land grant that says that, we've claimed the certificate of title. We are the sole owner. And we can take that original home with us and leave them with just a certified copy in their record that shows that you have that. And as long as that deed stays in your family, you stay on the property. If you decide to leave to go someplace else, or your kids don't want it or whatever, well, you don't sell the house. You just tell the county. And then if somebody else wants to go in, that they can have the house. That's how it's supposed to work, under the laws of God, if we're to live in paradise. These grants, whether of lands, honors, liberties, franchises, or aught besides, are contained in charters or letters patent. That is, open letters, so called because they are not sealed up, but exposed to open view, with the great seal pendant at the bottom, and are usually directed or addressed by the king to all his subjects at large. So when he's sending something to everybody at large, it'll have the seal at the bottom. I don't know which one to think of right now that would have the great seal at the bottom to all his subjects at large. All I can think of is if your seal, so you have to look at it this way. Back when they did this in common law, nobody knew how to write their name way back when. So when they first started doing deeds, they would put their thumbprint on it, right? Well, then they went from a thumbprint to an X, a red X, maybe in their thumbprint. Well, then we got further along, and it would be somebody would write your name for you, because now we all have names by now. They're starting the name game, starting to collect all the names and add the surname to the given name to make it a person and not a man. And then they can claim some jurisdiction. So if your signature is actually your seal, then when you write a check, maybe that's what they're talking about here. We'll have to think about that. And therein they differ from certain other letters of the king, sealed also with his great seal, but directed to particular persons, and for particular purposes, which therefore, not being proper for public inspection, are closed up and sealed on the outside, and are therefore called writs close, and are recorded in the close rolls in the same manner as others are in the patent rolls. So the letter patent is that would be the grant of land that the warranty deed is going to say that you're the registered owner of. That it's an open letter. It's sitting there someplace in a file, open to anybody, and anybody could claim it. That's why it's a public record in that manner. But there's other ones that are just directed to particular persons which aren't open to be read, although they are recorded. They're recorded as close rolls. And again, for a king to either get or give property, it has to be on the record. So there's a closed roll somewhere. And I never read this directly from the Bible, but I've seen it pulled out before, that talking about an earthen vessel with a closed deed and an open deed, and to be held inside. Well, if the open deed is your property you're going to live on because it's open, well, what's the closed deed? Well, we're going to find out what that is, because one's for real property, one's for real estate, it's open, but there's another one to a particular person's. It didn't say person, it said persons. That's like saying 3 times persons. That's one way they can say you're a man, by calling you a person. In Law of Nations, D. Vitale calls them a moral person. Well, to be moral, you have to have a conscience. So that's his way of saying man using persons. Uh, so it does the same thing as a letter patent, but it's closed. Grants or letters patent must first pass by bill, which is prepared by the attorney or solicitor general in consequence of a warrant from the Crown, and is then signed, that is, superscribed at the top in the King's own sign manual, and sealed with his privy seal, which is always in the custody of the principal Secretary of State. And then sometimes it immediately passes under the Great Seal, in which case the patent is subscribed in the words, by the King himself. So an open letter patent, this could be what they're doing with real estate, right? I've never seen what a letter patent looks like, but is it superscribed by somebody at the top, the sovereign, and it works its way down. And now you're the grantee because the sovereign gave it to you on the real estate side. But there's another way. Otherwise, the course is to carry an extract of the bill to the keeper of the privy seal, who makes out a writ or warrant. So if they're saying writ or warrant, I'm going to say it's an order. To make out an order, thereupon to Chancery, so the sign manual is the order to the privy seal, and the privy seal is the order to the Great Seal. And in this case, the patent is subscribed by writ of privy seal. So I'm thinking that the notary may be playing our Secretary of State. I've not looked into that to see if there's any way to put those two offices together. Because it would go from there, then it goes to the Great Seal, which is the seal of the court of record, right? And you're the tribunal of the court of record, so that's your court where you live. That court of record is your court of record, and you're the tribunal. And that would be the Great Seal. Because in law, the largest political subdivision there is a county. Okay. But there are some grants which only pass through certain offices, Admiralty or Treasury, in consequence of a sign manual, a signature, your seal as a signature, without the confirmation of any other seals, basically. That would be like a check, right? That goes through the Treasury. Your promissory notes, all those other things. So all these things are grants from the King that are going through the system. I think we get all those back. I think they're our property. The manner of granting by the King does not differ from that by the subject. The construction of the grants were made. Grant made by the King at the suit of the grantee shall be taken most beneficially for the King. There really wasn't that much in these. Or at least I haven't been able to fit it in with what else I have in my head. But I want to get because I want to get to the forms before this thing gets too long. And this is granting to aliens, and you can all go read it for yourself. So if we grant our lands, which is our, or some part of our estate, us as a king, the best that we can give to somebody else that the grantee can be is a tenant at will. That's the highest status they can have. It's only by our will that they can be there, right? So you can change your will at any time, and they're no longer on the deed. And so that would be like doing a power of attorney, right? You grant it to somebody until you're done and say, well, I take it back. You have it by my will. And as long as they have the power of attorney, they're going to do what they're doing. Now, again, in the definition to record, it says that once a deed is lawfully recorded, it acts as constructive notice to all interested parties. So I don't think you need to tell anybody. It says in the definition it'll be taken care of. we'll have to wait and see what happens next. But maybe we need to write an order to somebody to, hey, where's the rest of the real property and interest to this real estate? And to prevent deceits of the king with regard to the value of estate granted, it is particularly provided that no grant of his shall be good unless, in the grantee's petition for them, express mention be made of the real value of the lands. So we're going to stop here for this, and we're going to go look at what I think is this closed roll, letter patent that they're talking about. And let's start with this. Give me just a minute here. View, rotate. Okay, I copied this off. A buddy of mine sent me his hospital birth record, the one that came from the hospital, and that on the back are the footprints. Well, this is what the front looks like. Picture of the hospital at the top. So I believe that this page in the back, and the back side of it has the footprints in, are the diploma land patent, also known as the closed court roll. And this certifies that the landed estate, which is your all capital R name, was born to your mom and dad in proper case in this hospital at time da 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 da. So they didn't produce you, they produced your land. And it's a landed estate. There's the land for the estate. That's what's produced at your birth. That's what they're recording. They're not recording a human. They're recording that your landed estate was created. And then it says, a witness whereof the said hospital has caused this certificate to be signed by its duly authorized officer and its official seal to be herein affixed, the director, and then it has the attending physician on it, and it has the hospital seal on the left-hand side. And when you look up the definitions, like for what director might be, besides what you might think it is, or physician, or a hospital, or a seal, to me this is the outside. When the thing is rolled up, this is what would be on the outside, right? It's describing what's on the inside, but it's not telling you what's on the inside. So let's look at the back. So again, this certifies all this did, right? This is the one you get at the hospital the day you're born. This certifies that your landed estate was created, was born to your mom and dad. All right, so they've just created an estate. It's an estate of land. So what'd they do with this estate? Well, let's see what they did. That's the back side. Okay. So everything on this is in proper case or just lowercase. And the first line was family history. Has the father's full name. He's the sovereign. It has his first and middle name and about 5 spaces, and then his last name. And then there's the birthplace and the date and the mother's maiden name. Again, these are upper lower, just a proper case, and then a residence. So here the sovereign is granting, because he's when mom and dad get married, they form a union. He becomes the sovereign of both estates. He's the grantor, and he's granting it to. This is all in lowercase. Sex of child. Child is lowercase. Boy in lowercase. Weight at birth. How much it weighed, or how much you weighed, excuse me. How long you were. So he's given the boy this estate. Doesn't have your name on here. Doesn't have your Christian name on here yet. You know, a boy is in lowercase, child is in lowercase, and that'll make a difference when we go to the next one, because these names will change, or the word will become capitalized. So what did he give him? Well, he gave him some land. He gave him that much. 9 pounds, let's say 9 pounds, 8 ounces, 22 inches in length. The left footprint and the right footprint. And then on his, it said mother's left footprint, or thumbprints, but they were blank. There was nothing on there. And you can see that the seal from the front is embossed into the back. I don't know if that's important or not, if that's just because that's the way it is, probably. But then it has this neat little statement at the bottom. This certificate of birth has no legal value. If it becomes necessary to acquire proof, and proof is evidence, of date of birth, the date that the estate was created, a certified copy of the official birth registration may be obtained from the health department, City of Tacoma. So the official birth registration, that's the certification of live birth. Excuse me, certificate of live birth. So it's saying if you want something with legal value, that's proof that that's what you're supposed to get. And so this document represents the land patent, and the certificate of live birth represents the warranty deed. And just like with the warranty deed, it's missing some things. We haven't accepted it, and right now it's only under one seal, the copy that you get. All right. So we're going to go back to this for a minute, because now we're going to talk about fines. So the hospital paperwork is what we just read up till here. Creating the land patent or the landed estate. One is an open deed, like you have for real estate. The other one's a closed deed, which is the real property and interest, the landed estate, because it's made out to a particular persons. Persons being, I think, 3 persons making a man. We are next to consider very usual species of assurance, of which is also of the record, a fine of lands and tenements, which it will be necessary to explain. A fine is sometimes said to be a transfer of property of record. So the record is on file, and now it's going to be transferred to somebody, just like the land patent's on file, and with the deed, it's transferred to you. Well, now we're going to transfer the real property and interest, which is our all capital letter name. Though it might be with more accuracy to be called an acknowledgement, guess what? There's the word acknowledgement, of a transfer of property on record. So again, the record already says that you are. We just never acknowledged it, just like your deed did for your house. As people are finding out today, this week, people are getting their deed to say sole owner. It's never happened before, as far as I know. And we're going to do the same thing with the real property and interest, known as your all capital letter name, and it's going to be in the same frickin' building. Maybe the same office. Let's find out what we have to do to get that. Okay. By which it is understood that it has at least the same force and effect with the transfer of property and the conveying and assuring of lands, though it is some of those methods of transferring a state of freehold by common law, though it is one of those methods. Okay, I better start over here. Let's just start from the beginning. A fine is sometimes said to be a transfer of property of record, though it might with more accuracy be called an acknowledgement of transfer of property by record, by which it is to be understood that it has at least the same force and effect with the transfer of property in the conveying and assuring of lands, though it is one of those methods of transferring a state of freehold by common law, in which livery of cession is not necessary to be actually given. The supposition and acknowledgement, therefore, in a court of record, however fictitious, inducing equal notoriety. Okay. When you were born, right, that's considered livery accession, commonly known as delivery now, where this estate has just been created. But at that second, it's just been given to you at that moment. But then this piece of paper doesn't require that to be done. This is the beginning of the fiction here. We're going to have some paper replacing the human. And it didn't require a livery accession to do the paper, but to create the estate, it did require a livery accession. But more particularly, a fine may be described to be an amicable composition or agreement of a suit, either actual or fictitious, by leave of the king or his justices, whereby lands in question become or are acknowledged to be the right of one of the parties. So we acknowledge the deed, and now we had the right. It's an amicable composition or agreement of a suit. It should not be contentious. Either actual or fictitious. You were born, that was actual. Fictitious is this landed estate that's been created on a piece of paper. In its original, it was founded on an actual suit commenced at law for recovery of the possession of lands. So they're just telling you that what they're doing now comes from this way it was done in the past, in common law back in feudal times. And the possession thus gained by such composition was found to be so sure and effectual that fictitious actions were and continue to be every day commenced for the sake of obtaining more security. So this is, right, they always want more security. They want you to write more paper. That's right, everything is a security instrument. And it's so sure that it allows them to do that. Hey, I didn't write the rules, they did. A fine is so called because it puts an end, not only to the suit thus commenced, but also to all other suits and contrivances concerning the same matter. So anything that's attached to it comes to an end once you claim it. Or, as it expressed in ancient record of Parliament, luckily it's in English, and when you see this stuff in law books, it's in Latin, you really want to go cut and paste it, see what it means. There is no greater or more common security provided in the Kingdom of England, or by which a person can acquire a surer title, than by a fine levied in the King's court. Nor can any testimony be produced more customary for continuing a title, or for confirming a title. It is called a fine because it puts an end in all consummation of the suits, and for this purpose it was provided. So that piece of paper is the fine, the warranty deed is the fine, and so is this right here. I believe that this is the fine for the real property and interest. Let's take a look at this baby. Get it down here where we can see it better. Okay, there's lots of things to see here. First of all, it's got a birth number, and then a local file number. So from the red here, this is your grant deed, your warranty deed. Most things are uppercase. You'll notice the word like child on here is uppercase. On the one I showed you before, it was in lowercase. Yeah, so it was lowercase on the hospital form. On the hospital form, it says the sex is a boy. Here it says the sex is a male. And it's in all capital letters. This one doesn't have the baby's weight, or I don't believe it has length on there either. So I got to make this bigger so we can actually read this. Forget the notes for a minute. How big can we get this? Okay. So as you can see, everything is in capital letters. Michigan, Bay, child's name is in capital letters. And so now we're talking about the fiction, and this is where Robert Allen Rytlewski, right? That's the landed estate that was created with the birth certificate form, or excuse me, the hospital form, because on the front one, we go to the front of this real quick again. Hang on. This certifies that your all capital letter was born. So now it's going to be registered, because when we get down here to the bottom, let's go to the bottom real quick. The local, I was born on September 5th, so September 18th, the local register got this information. I believe that's what it's saying. And here it has your under father a child, mother a child. It's your mom and dad, upper lower, with your mom using her maiden name. And this is just, so this is the extract of the bill. Now it's a fine, right? Where the union of mom and dad created a landed estate. This is just showing that the evidence that this closed roll exists for this landed estate set up by your mother and father. Because your father's the sovereign of the union. Compared to what we're going to see next, where we have the mother as the informant. So I think here the mother is an informant, because it says below that for the doctor, hereby certify that I attended the birth of the child who was born alive. See, this is small. This is lowercase child, was born alive on the date stated. Let's see if I can read on mine. On the date stated above. So I think that they're witnessing that the landed estate was created and the child was born. The child of God is born and inside the body. This is the first time you were born. Some years later, we were considered dead or lost. And someday soon we'll be born again when we take this back in. All those years in between, we've been considered a person, not a man. So on this, the reason I say, well, let's look at this real quick. All right, so here's the information, right? And, you know, a competent officer has put a certificate on it. This is just like an acknowledgement certificate on the deed. That says that Stephen Toth, clerk of the court of Bay, or excuse me, clerk of the county of Bay, doesn't say Bay, Michigan, it says county of Bay, upper lower, and of the circuit court thereof, the same being a court of record, having a seal, do hereby certify that the following is a true copy of the above record now remaining in my office, and the whole whereof, and the whole thereof. So this is a true copy of what he has in his office. And when he says the whole thereof, because it's talking about an estate, the estate hasn't been split. The whole of that estate is still there. The whole estate of Robert Allen Rytlewski, all capital letters, is still in his office. And he has affixed the seal of the circuit court on here. So, you know, that all sounds good, but at the end of the day, it doesn't matter who they are. They're all justices of the peace. A Supreme Court justice is a justice of the peace. Well, so is a notary. So if we have to go have a notary's certificate authenticated, get a certificate of acknowledgement for, do we have to do the same thing with this? Now, I find this interesting on these because if you'll see, he signed this one, and I've never seen a signature from him before. So I'm trying to figure out what capacity he's doing this in, because at the top he's Stephen Toth, all capital letters. On the bottom he's Stephen Toth, upper lower. On the top he's the clerk of the county of Bay and the circuit court thereof. On the bottom he's a county clerk. Well, a county clerk must not be the same as a clerk of the county of, or they would use the same name. So they have to be different offices. So he's certifying that it is, and he signed it. And in common law, a signature is a seal, so he sealed it. And then it looks like he's witnessed his own seal from a different office, from the county clerk office. I haven't really got that straight in my head, but nevertheless, I think you take this down and say, I need to have this man's oath certified. And they had to go back and look in the books, because this was back in 1984. He's probably dead, but at one time he did. And have them put their seal on it, give you the second seal to this document to make it a public record. So we cover everything here. So it's a true copy. Yeah, and get the certificate of authority for the certificate officer. That's what I would do with this. As well as do, if this is the warranty deed, well, you need to accept the deed. So you would write an acceptance, just like we're doing for real estate, except you're accepting the deed for Robert Allen Rytlewski as the owner. You're accepting the deed that was given to you by the king, the sovereign, your father. And it's been sitting on the shelf since your birth, waiting for the proper owner to appear and claim it. And this is your claim check. Now, here's one more to look at. So this is the certificate of live birth. And one last one. This one here is the certificate. Certified copy of record of birth. Ivan Stephen Toth, clerk of the county of Bay and the circuit court thereof. Again, I pointed that out because he'll have a different name at the bottom, but at the top, I think he's the grantee on this. The following is a copy of a record of birth. So it's a copy of the landed estate, Robert Allen Rytlewski, not a true copy, now remaining in his office, and the whole thereof, so it's still the whole estate. It's what was recreated. It's what was created with the certificate of live birth. The child, the all capital letter name child, is there. And it looks to me that Robert Allen, it's been granted to me, that this estate has been granted to me. And that it's been recorded in Lieber Book F on page 2137, October 7th, 1958. So that's when it was put in the record, and it's on that book. The interesting thing, though, is if you look at this, so mom and dad as creators of the landed estate for the Christian name. They created the estate, Robert Allen Rytlewski, for the Christian name, given name, Robert Allen. And on here you see that father is in lowercase, normal case. In other places it says father in uppercase, and apparently all that shit makes a difference, or why would they do it different? In witness thereof, I have hereunto set my hand and fixed the seal of the said court of record, 29th day of July, 1963. And there's the seal. Now, the funny thing is, again, in common law, you don't have to sign your name, right? You can use the seal. He said who he is at the top, and he's using the seal as his proof. Signatures don't mean jack. It's all about the seal. Seal is signature of common law deed. If officer does not have his own seal, you can use a signature. So when he's the Stephen Toth of the county of Bay in the circuit court, he has he has one. But here at the bottom 'bottom, 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 'b Well, the county clerk doesn't have his own seal. His seal is the court of record. Actually, he doesn't have a, well, I'm going to say that office itself doesn't have a seal, but because these offices are intertwined in that office is a seal for the court of record. That's why when you give you your certificate of authority, it comes under the seal of the court of record. But Stephen Toth, the county clerk, doesn't have his own seal, so he signs his name, Stephen Toth, that's his signature, even though it's typed. But it's not a signature, it's his seal. It acts as his seal. So there's one witness, and the second witness is the deputy clerk. They're both competent officers. So, and as you can see, this was produced in 1963. So 5 years after my birth, basically, they produced this record of life, certified copy of record of birth. And it was delivered to me because I've had it in this little manila envelope, and on the front it just says where the name is. It says Robert Allen. It doesn't have the last name on it. So what happened is we got, so if we go to this one real quick, right? So here we are. We have this to start with. This is our claim check that we were supposed to take in and claim, right? And what it produced at that time was this put on record that says that you are the owner of the all capital letter name estate. But because you never stepped forward, and because your parents are considered dead, because all this never happened, right? That we don't know what happened. They have leased out this. They, being a guardian, they appointed a guardian ad litem to take care of your estate. So if you don't show up in 7 years to do this, then you're considered dead. Now, maybe it's 5, because this was about 5 years. I don't know. So this just shows to me where it's been recorded at, and the date of record was October 7th, 1958. And on that record, it shows that the estate was created on the day of your birth. And your certificate of live birth is your proof when you acknowledge it, just like a warranty deed, that that you're the proper owner. And this one here then is, I don't know, your certificate of your share. Who knows? Your capital share. I don't know. It's just it's more evidence. See, this is some kind of deed because it's been given by a grantor to a grantee, Robert Allen. He's put his seal, and so have 2 other people. So it's just like the grantor having done his thing on a house. The exact same thing. And we just haven't acknowledged the deed. So I guess what I'm saying is I'm going to acknowledge both of them, basically, because one is the, I believe, the indefeasible title to your land, and then this one here is the landed estate, that for the not the real property, but the interest, which is the personal property. And that's all stored in this account under the certificate, certified copy of record of birth. Well, if I haven't confused y'all, if you have these, let's start taking a look at them, because this is the next thing, and this is done at the birth county. Land never leaves the county, man. How can land leave a county? It can't. So it's all at the county. That thing you get from the Secretary of State, your vital record. Now that's that's an extract from this. And in Minnesota, Rule 220, it says that if you do a properly formed affidavit with this certify or a birth certificate, a vital statistic birth certificate, vital record, basically saying that you're a party of interest in that record and what it represents, that you can take it to the